Good afternoon. My name is Sarah. I serve as the board administrator for the Texas State Board of Examiners of Marriage and Family Therapists. I'd like to call the roll to determine a quorum. Dr. Merchant,
Present.
Dr. Barty,
Present.
Mr. Castro,
Here.
Dr. Elder,
Present.
Miss Azell,
Present.
Mr. Hampton,
Present.
Mr. Price,
Present.
Miss Raina,
Here.
and Miss Richardson.
Present.
Thank you. We do have a quorum. I'll turn it over to Dr. Merchant.
Hello, I am Dr. Merchant, and I am the chair of the Texas State Board of Examiners of Marriage and Family Therapists. State rule requires, or the Open Meetings Act requires that the presiding member be present in whatever space the public is present in. I am Zooming in today from my home in Abilene, and so I am not there. And so because of that, I'm going to appoint Dr. Jody Elder to be the presiding member of today's meeting. Dr. Elder?
All right. Thank you, Dr. Merchant. All right. So I have 106 and I'm calling this meeting to order. We have a quorum. Thank you, Ms. Fasholtz. The first item on the agenda is, do we need to excuse any absences? I don't think so.
No.
Okay,
No.
got it. I wanted to kind of open it up for board member thoughts and feedback because this is our first meeting where we're using kind of the brief from our previous meeting instead of meeting minutes. We discussed in September transitioning over from very detailed minutes to more of a brief model with timestamps, which Ms. Fasholtz produced for us beautifully. And so I just wanted to see what, if board members had any thoughts or feedback about that new format.
I really like the new format. Just very concise, tells us what we decided, like what the action items were, the follow-up. I don't know. I thought it was really cool. I don't know what everybody else thought.
Ms. Richardson, call your hand.
I liked it and I thought it was very detailed. Thank you, Sarah.
Is it too detailed? Okay.
No,
It's easy to read.
yeah, I like it because it's detailed enough to bring to mind kind of the flow of the conversation.
Sarah, how long
Keep
did
it-
it take you to type that?
It's kind of an ongoing process because sometimes there were follow-up entries. It was maybe 2/3 of the time that it takes to do the minutes.
Is there a way that we could shorten it to make it even less time consuming for you?
Part of the difficulty is whether or not we have a good quality recording, and how many times I have to go back to hear who made the motion or that kind of stuff. It's helpful if you say, "This is Sarah, I so move," or "I move," etc. When we're not all on Zoom, and for instance, when 5 or 9 of us are all in the same room, it's difficult to see who is speaking. And I can't always distinguish the voices. So that's one thing. If you can identify when you make the motion, that might make things a little faster for me.
Okay. Or also like as chair or the presiding member saying things like, Dr. Barty makes a motion, Miss Raina seconds, things like that might also be helpful.
Correct.
Okay.
Would you like that in today? Does that help today, even in this, when we're all on Zoom?
Yes, anytime the board meets, that would be a good practice. Is that what you're asking?
Yes.
Yes.
Okay.
Okay, hearing no further discussion, thank you, Ms. Fasholtz, for that transition. And I'm super glad to hear that it's taken less of your time to produce that document, because that's the goal, to get as efficient as possible, because you have lots of other things on your to-do list. All right, so that was item 1. Let's move on to agenda item 2, which is welcome and announcements. And so I want to let everyone know that our next board meeting was scheduled for April 10th. We discovered at in previous discussions, that's actually during the Texas Association of Marriage and Family Therapy conference. And so that meeting now has been shifted to May 29th. So please make that note on your calendars to remove the April 10th date, add in the May 29th date for our next full board meeting. And the TMFT conference will be in April 9th through 11th in Galveston. And Dr. Merchant, I believe you're going to be presenting there an update about our rules and complaint processes. And also Ms. Fasholtz, my understanding that you'll be attending and kind of covering an exhibit hall booth for attendees to be able to interact with the board, which I think is great. And Dr. Merchant, I think you had a few things you wanted to add under this item as well.
Yes, I will also be presenting to the San Antonio Marriage and Family Therapy Association virtually on February 13th. It'll be a 3 hours kind of ethics update, and so I'm excited to be able to do that. I also wanted to announce that Dr. Wayman Henson died yesterday after a short battle with rapidly progressive dementia. Dr. Henson served as the presiding officer of this board from 1998 to 2008. He also served on the AMF-TRB board. He served on the TMFT board. He was at ACU from 1984 to 2008, and so he's was just a Texas MFT for a long time and a psychologist, and just contributed to the field quite a bit. I think his greatest life work, however, was he was a researcher and advocate documenting the Black farmers' fight against the USDA. And so he just did some really important work there. And anyway, so I just wanted to take a moment and just let our board know and let anybody who's watching know about his passing.
Thank you. Definitely a legend in our field, especially in Texas.
Yes. He'll be
Any other?
missed.
Sorry, Dr. Barty, go ahead.
Well, if we're doing the announcements about presentations, next month I'm doing a presentation on ethics with the Fort Worth Association of Marriage and Family Therapy, and then I will also be presenting at TAMFT in April.
Oh, really? What's your topic?
Bohemian, I don't know exactly what it is. It sounded good when I wrote it. Something along the lines of using Bohemian approaches in supervision with supervisees.
Sounds like a worthy topic.
I think it'll be fun.
Well, thank you for sharing your expertise. And since we're making announcements, I'll be presenting February 6th, the first Friday in February, a 3-hour ethics workshop that's basically updates for LPCs and LMFTs on their rules. And I'll be doing that for the Relational Therapists of Dallas, which is kind of like the Dallas chapter for TMFT. Any other announcements? All right, great. Doing good work, reaching out to the community and showing up for our stakeholders. Way to go, team. All right, moving on. Number 3 on the agenda is public comment. Ms. Fasholtz, we do not have anyone in the room in person. So I am going to kind of hand it over to you to cover the switchboard in old-fashioned terms for anybody who might be joining virtually.
Sure. So if you are joining by computer, please use the raised hand feature. There's a button at the bottom of your screen to raise your hand to signal that you'd like to provide public comment. Please identify yourself or the organization that you are representing. You'll receive a message asking you to unmute when I call on you, and you'll have 3 minutes to provide your public comment. This part of the agenda is not intended for a discussion or a question and answer session with the board, but it is to allow the board to be informed of your concerns or your questions or your opinions, that kind of thing. And in lieu of public comment verbally given at this type of meeting, you may also provide written public comment either by the link on the agenda or through our Contact Us webpage. So let's look at. I see no hands raised. And I see no one is attending by telephone, so I believe that ends public comment.
Okay, And the board was provided written public comment from 3 submitters. So just to kind of bring your awareness to that.
In addition, I checked the responses from the link on the agenda as of 5:30 last night. There were no entries in that forum.
May I make a comment about some of the written public comment that we received?
Absolutely. Is this the part, I would assume this is the part in the agenda where we can discuss that.
Yeah.
Right.
Well, I mean, I would just want to say a couple of people mentioned that we had a couple of public comments related to counting hours acquired in your master's program. And so I just wanted to maybe remind people that that is going to be going away relatively soon. And so it's like a moot point that's going away. And so we're not going to be counting hours from your master's program in the future, eventually. Like it's going to be a while before that actually fully takes form. But um, anyways, just a reminder of that. And then people were also curious, like why we don't just go ahead and do like the hours calculations when somebody submits the form. And so just again, as kind of a reminder, the reason we don't do it immediately when somebody submits the form is because rules change. And so consequently, we're not going to count those out. We don't want to count hours and make a promise that we're going to not be able to keep, if that makes sense. I don't know. Does that make sense?
It does make sense because it's important for applicants to keep in mind that the rules that are in place at the time of the application is
Right.
actually that apply to the way that that application is processed. So let's say a person graduates, they have excess hours, they want us to count them then and say, okay, now you have 100, so now you only have to get 1,400 direct clinical services. But at the time, 2 years later, when they're actually applying, that may no longer actually be possible. That's why we don't
Right.
count when they first graduate and apply for their. Nicole?
Dr. Elder and/or Dr. Merchant, would it be worth us just saying, like explaining a little bit why, as to Dr. Merchant's comment about like we're not going to be doing that forever? Would it be worth kind of saying why we won't be doing that forever?
Sure, go for it. Oh, I thought you were asking to share that information,
Nope,
Mrs.
I was going to let y'all do it.
Basically, it's not consistent with our statute. Our statute doesn't allow for us to be able to count hours acquired in a master's program. And so I believe it's up until I'd have to go back and look at the rule to be certain, but I think anybody who begins their master's program after September 1st, 2025 will no longer be allowed to count hours acquired in their master's program. So if you graduated before then, you can still count hours from your master's program, but past that, you will not be allowed to.
Right. In our most recent quadrennial rule review, that was flagged as something we were extending to applicants that wasn't in line with our statute. So it's
Right.
no possible.
Yeah. Anywho.
Okay. Any other discussion about the written public comment? Okay. Then we shall proceed to item 4A, which begins with the report from the board chair, Dr. Merchant.
Yes. I actually don't know that I have a whole lot to say today, which is unusual. I feel like normally I talk for like 20 minutes here, but a lot of the things that are priorities for me are just a lot of things that are going on. We're going to actually address in all of the committee reports. So I don't really have anything to say. I'm excited about Sarah's new briefs that she posted for us, and that's it. I don't have anything else.
All right. Moving on, then we will move on to the report from the board delegates to the Texas Behavioral Health Executive Council. And Dr. Merchant serves as our professional representative and Mr. Hampton serves as our public representative. So I want to open up the floor for them to provide information about BHEC goings on.
Uh, I'll just jump in and say that the BHEC Rules Committee, you'll have a lot of information in your packet. I don't know that I have a whole lot to add to what was anything beyond that was in the packet either. The BHEC Rules Committee did not meet this quarter. And so sometimes I'll have like things to report from that, but we didn't meet and we won't meet again until March. So I don't really have anything to report there. I do maybe want to just draw y'all's attention to the guide for new and emerging practices in technology. I think that's a pretty good document, a pretty cool document that BHEC approved and should be posted on our website now. We also have the upcoming TRIO rule review. This will be slightly different than the 4-year rule review that we just went through. We don't have, to my knowledge, and I will let Patrick or Robert jump in, but we don't have a plan yet for the trio role review. We just have the email that you all have seen, and I don't think there's any update beyond that. Um, we also voted, BHEC did vote against posting the guidelines for practice monitoring. That is something that we had created in our outreach committee and then taken to BHEC as maybe a guide to post on the website. And there was just concerns about maybe scaring people away from doing practice monitoring if we posted guidelines, some other things. And so they want to use it as an internal document so that if somebody does reach out to the board and kind of has a question about what it means to be a practice monitor, they can use it as an internal document, or whenever somebody agrees to become a practice monitor, there's maybe some language from our document that they would go ahead and send to provide some clarity. So I think they're going to use it internally, but BHEC did vote to not post that on the website. We also had a listening session on ketamine, assisted psychotherapy. And I was very helpful, a very insightful listening session. I don't know if any of y'all tuned into that or not, but basically, BHEC has just had concerns about medical safety whenever somebody is taking ketamine in a therapist's office and whether that's considered unlicensed practice of medicine. And, we just are kind of trying to understand what ketamine assisted psychotherapy even looks like in Texas. And so that listening session, I think, was really helpful to kind of give us a better picture of exactly what that looks like. We've not met since that listening session, so I don't really have an update other than we listened, we learned, and it was a really good meeting, I thought. Um, and then the only other thing I have is during the BHEC meeting, we passed a rule that I think Robert is actually maybe going to talk about in the next section in the report from the board administrator and other staff. But there is a rule that we passed, that we proposed, I should say, that we proposed 884.11. And well, anyways, I don't think I'm going to say anything else about it. Robert's going to talk about that in a minute. But anywho, Mr. Hampton, do you have anything you want to add?
Nothing to add.
Okay. Are there any questions about what's happening at BHEC or just kind of any of the things that I drew your attention to?
I have a question. I'm super excited that the ketamine assisted psychotherapy listening session happened. I tried to go online to find it and listen to it, and I either wasn't looking in the right place or the recording is not posted. So I guess this is a question for either Dr. Merchant or staff. How might we access that asynchronously?
We
Uh,
we do have that recording, but we don't have it posted. But anyone is welcome to ask us, and we can share. We had some technical difficulties, and we lost. Really sad. We lost all of the chat and the Q&A. It didn't record, and so, um, but we can get the recording, the video to you if you'd like.
Is that something we'll be posting just to kind of make it like on our BHEC YouTube channel?
No, we had some concerns about that we don't want people to think we're further along than we are. I think that's the reason Daryl's hesitant to put that out there because we're not sure how appropriate it is even for us to try to regulate this field until we've coordinated more with the medical board and the nursing board and pharmacy. Um, so the town hall was really meant for our benefit, not the public.
Okay.
So that's kind of that decision.
That makes sense. It sounds like it was just a way to open the conversation about it to see what's going on. So yeah, great. Anything else from our BHEC delegates? Okay, then we'll move on to the next item, which is board administrator report.
Thank you. So I just want to show the website real quick. I'm not sharing the website. Do, do, do. That one. Okay. I just wanted to bring to your attention, if you're at our homepage and you click on the left-hand side, the top of the gray bar, Quick Links Agency News, and then scroll down a bit to the 2025 Customer Service and Strategic Planning Survey. It's been open for some time, but it will close on January 31st. So if you've not completed the survey, just wanted to encourage you to do that. Also wanted to bring to your attention how you can find the guideline that Dr. Merchant just talked about. If you go to from our homepage, go to the Family and Marriage Therapist drop down, then slide down to Forms and Publications, and then you can slide down that page to the Policies and Guidelines. And the BHEC guidelines for new and emerging practice or technology is the newest publication there. Also from the homepage, on the left-hand side in the quick links, you can slide down to the workforce survey and data. It's fifth or sixth from the bottom, and that will take you to our workforce survey. A new survey has been opened, and it will be open for this year. So just wanted to bring to your attention to complete that survey if you've not done so. Board members, in your packet, you have reports on the leadership events, leadership listening events that the staff held on September 29th, December 8th, and January 16th. We've had good comments. People enjoy having the opportunity to speak with staff, and the attendance remains robust, so those were good things to do. The rule that requires CE broker is in full effect, and I'd like to show you how to find. If you don't have your account yet, I did want to say how to find that. So I'm going to go back to the top and click on the masthead to get back to the home page. This blue button on the left-hand side, Renewals and CEs, clicking on that, I get the renewal page. And I'm going to slide down a bit to the Continuing Education Reporting and click on that bar. And that will tell you more about the CE Broker platform, the rule that is now in effect that requires you to use the CE Broker, how to do your account. And there's lots of resources. We held 3 different demonstration webinars. There's a video recording of each one along with transcripts and question and answers and a presentation from CE Broker themselves. So most of your questions can be answered there. And then if you have any difficulty, once you're in CE Broker, they have a quick link to their help desk. So be sure to be using that, because you won't be able to complete your next renewal without reporting to your continuing education to CE Broker. And board members, in your packet is performance measures for fiscal year 26, the first quarter. They will be presented to the council on February 17th. So if you have any questions, you might want to tune in to the February 17th meeting. Director Spinks reported that he has attended the inaugural meeting of the Health Professions Workforce Coordinating Council that was created by the 89th Legislature in House Bill 3801, which abolished the statewide Health Coordinating Council and created this new Health Professions Workforce Coordinating Council. And board members, just wanted to bring your attention, January 31st is the deadline for acknowledging the annual receipt of your board member training and the Department of Information Resources Security Awareness Training video. So if you haven't responded to those 2 trainings, then do so at your earliest convenience.
Ms. Basholtz, could I ask a question about that real quick? I
Yes.
tried to do the acknowledgement form for the cybersecurity awareness training video, and it sent me to this page that said this form is now closed. Did any other board members have that experience?
I saw it.
Yes, I did. I saw that. It says it's closed. That was about a week ago.
Okay, I'll check into it. Thank you.
I had just a follow-up question about the CE rollout. And maybe this goes to Ms. Fasholtz, maybe it goes to Mr. Romig. Just curious about, other than the typical, it's new, it's change, it's uncomfortable, have there been any hiccups or problems with the rollout, or has it gone fairly smooth?
For the vast majority of folks who have signed on, it's gone very smoothly. The two sort of common actual hiccups. One is this has caused our licensees to realize that um, across the different boards, license numbers may repeat because the boards were separate back when they were created. You issued license numbers that were the same as others. And so you could have someone who has the same number under the social work board that has an MFT license. But that's just a minor inconvenience. The CE broker knows who you are, and when you create your account, you have to tell it which board and which license you're under. So it's not actually caused any issues. It was just a surprise to folks to learn that. And then the other is typical folks. It is frustrating sometimes, but you have to input all the information yourself about the CEs you took. It's not smart enough yet to just scan the certificate and put the information in. Someday maybe. So, and then Dr. Elder, Mr. Price and Miss Richardson have their hand up.
Oh, I can't see it. Okay, I'm sorry. Yes, Ms. Richardson.
Geez, man. I was just gonna ask, I've been in a couple of networking events recently, and people have mentioned that they really appreciate that that BHEC will now send out emails notifying them if they're on the email list, hey, there's been a rule change to thus and such rule. But some of the feedback has been that but they'll click on the link and it just takes them to the rule and they don't always know what has changed. And I wondered, I really like in our get ready with me packets that we get an attachment for each rule of you know, it's very clear to us what is changing. So the old stuff being crossed out, the new stuff being pointed to or highlighted to. And I wondered, in those emails that you're sending out to people, could we send that attachment as well?
Those are published, aren't they?
They are
Molly?
published with the meeting stuff, but I wondered if when we push out the notification of the, hey, the rule has officially changed, could we attach that too? Because I've heard from multiple people that they don't know, they didn't realize that stuff was published, and they don't necessarily want to dig through a packet of information about our meeting and agenda and all that stuff. So would, if this is a headache, then understood. I was just making a suggestion if it's not an undue burden.
We've gotten that feedback, and we are actually looking into. I don't know that we're going to do exactly that, but we are considering, is there a way to more effectively show folks what has changed? I will say for when people get the email about the rules being proposed, the link that they get does show the strikeouts and the markouts, so they will see what changes. When they get the email of what has been adopted, the way the register works is it's showing you the final adopted rule. You can navigate to what the proposal was and the changes to see the strikeouts, but that does take a little more digging. So we have heard this complaint, and we don't have an immediate fix, but it's a good thought.
Thank you for that, Ms. Richardson, and for the responsiveness on behalf of the staff. Mr. Price.
Yeah, just two comments and one that kind of already got touched on. But I guess when I was looking at the town hall results, the ketamine one was twice the attendee list. So definitely a topic that's our constituents are hungry for. So I figured I'd just call that out. And then we touched on a little bit on the CE broker, but I would just be curious to know how we can track the effectiveness kind of over over the year and how we can be updated as a board on that. It's important, obviously, and a key interaction that we have with our license holders. And so I'll leave that to y'all to think about the best way to do it. And I realize we're probably only 23 days into the endeavor, but understanding how that's going is important, I think.
Absolutely. And I can tell you at least two things that we are doing to track already is CE Broker, I think, is going to send us a monthly report of how many people have registered. Um, we have, I think they said upwards of 25,000 already signed in. Now that is significantly lower than the 90,000, 95,000 people we have. But we would expect most people are going to register and report when they're getting up to their renewal point. But so we'll track that and hopefully we'll see a steady increase every month. We are also going to start tracking next month, and we're going to really keep an eye on anyone who's getting denied their renewal because they didn't report. And we know there may be some batch of those people who don't realize. And so we will take extra care to reach out to them and make sure they understand what's happened.
I appreciate that, Grace, that you're extending, because I do think it's a learning curve, particularly for people who struggle with technology, just uploading things. I've heard people say, how do I put this in here? And so I think it'll just take a minute for us all to get on the same page. Any other board members have comments before we open up the floor for Mr. Romig?
I have a question.
Okay. Go ahead, Ms. Reyna.
I'm just, this is just I'm not sure that this is a correct question, but would ketamine therapy be considered practicing medicine?
Yeah, we don't know. I think that's part of our inquiry, is if somebody takes it in your office, is that considered administration or not? And so that's why part of this whole work, we have to converse with, the Texas Medical Association, with the nurses, with pharmacists. Like, I think, like, just trying to make sure that we understand, even as a board or as a council, like what is in our lane and what is outside of our lane. So,
The scope of practice?
yes. Yeah. Do you want to say more about that, Robert?
I was only going to add that
Okay, sure.
we're monitoring the Texas Medical Board, who's actually going to be publishing. They've had several meetings about ketamine and ketamine assisted therapies, and they're going to be. They've announced that they're going to be publishing proposed rules about it. So we're monitoring those, and obviously, well, it's something that we would look into and follow along, because the administration of it, I don't know that that's something that our licensees are going to be actually giving it. I think it's more that people may be taking it and then therapy may be provided in conjunction with it. But there's a lot of we don't knows at this point, and so we're waiting to see what does the medical board's rules look like, what are their guidelines and recommendations and requirements, and then what steps can we or should we take after that.
And the only thing I would add is just for our listeners' benefit, that whatever comes out of this transpires, it will it will never be part of a therapist's scope of practice to prescribe or administer medications.
Very
Full
true.
stop, full period. Whether what occurs is a question, but that is not changing.
Thank you for that, Robert.
Yeah. Great question. Any other board members have questions? Okay, so then at this time, I think Mr. Romig will open it up to you to address the 884.11 public comments.
Thank you for that. I'm actually going to defer to Patrick if y'all don't mind, given I'm prone to a coughing fit if I talk too much, and I know this is a interesting topic.
So I'll go ahead and do my best Robert impression that I can for this topic. But the short of it is that some of this rule change. One of the reasons why I think this has not really been a topic of the LMFT board's discussion is this was brought up in an effort to combat, we're seeing a trend in a large increase in complaints across all boards. The issue is for LMFTs, your complaint volume is so much smaller that it's really not something that we've really brought to this board's attention, because I think at one point it was extremely low, a low number like down to in the 20s or something like that, where the others have hundreds. And so, but we've seen a giant spike. And so some of the things we look at is efficiencies, how to make sure that we're not having unnecessarily slowdowns or snags in the enforcement process. And so one of the things is, I think there's also been, this rule was proposed, and I think there's a lot of misconceptions about this rule. And I've actually had a phone call with an attorney who asked me, so does this rule mean that they're no longer entitled to ISCs anymore? I said, no, that's not what this rule is proposed. So it's really more of a clarification. And so under the current rule, even if we don't change anything right now, under the current rule, the structure, it allows for ISC. ISCs will be had if a complaint gets to that point. And an ISC can, right now, staff can just conduct an ISC without board members under the current rules, or staff can conduct them with board members. Some of the issues that come up, for example, one of the issues would be if a complaint was purely just, they didn't give me my records within the 15 days required by law, that's not really something that is, you counting time as to, was it 15 days, was it 30 days, 60 days? That's not really something where is necessary to involve board members, because it's not really there's not really a need for like a professional opinion as to, how to count time. But one of the issues that can't come up is if so staff can conduct an ISC in that sort of a complaint. But if during the ISC more issues come up where there are, scope of practice and standards of practice questions that come up, one of the problems then arises is after that ISC, under the current scheme, would staff be required to then go back and have a second ISC if there's new issues that are raised in the complaint that they have to investigate? And under the proposed rule, what would happen is, under the current rule, it's an open question whether or not they would need to do that. It may cause problems having to go back, loop back, have another ISC, move forward, or if they don't and they continue on, does it cause problems later down the road on an appeal or something like that? Under the proposed rule, what they can do is, if they can just conduct the IC as they did, new issues come up, and staff are allowed the flexibility to then involve a board member if they need be, or involve a professional reviewer and get a professional opinion. So there's more flexibility, but they still can and will use board members under the proposed rule change. So I think a lot of people have looked at this and seen how they were seeing wherever the change was and seeing something that they think is not necessarily there. So as proposed, it'll still have staff ISCs, it'll still have board ISCs. It's really meant to create some sort of unnecessary snags or slowdowns in the enforcement process, because one of the things we're seeing is we really need to make sure that our processes are as efficient as possible, and that there's not we don't have unnecessary burdens or slowdowns in that process. So again, this is stuff that we've seen much more like with LPC and some of the other boards that have hundreds and hundreds of complaints. But at a BHEC level, we have to create a system that applies to all of the boards. So whether or not for the MFT, you may or may not see any really change of how things are done, because a lot of these are going to maybe be more applicable to some of the other boards, but I don't know that it's I don't think, from what some of the conversations I have, people think that this rule is doing is not what they're suggesting. So I don't know if it'd be helpful if I answered any questions, or Robert, is there any other parts of the topic, top parts of the rule you think I should go over? But I think yeah.
Sorry, one thing I just wanted to add that I think also got lost in sort of translation of the proposed rule. Another thing we are doing is actually increasing board involvement potentially. In the other three boards, we have requested, and so far two of the three have done, to instead of having a designated one, two, or three board members that are available for the ISCs, that all board members are subject to us calling them to come forward for an ISC so that we have more flexibility and ability to get board members on those ISCs that we need. We have not proposed that for the MFT board because frankly, y'all's committee is working well for you and we're not having slowdowns on your ISCs. And so it hasn't been necessary. But I just wanted to highlight that we really aren't, this push by staff is really to try to move things more quickly, not remove the board from these decisions.
Just to clarify, you're not saying that all 9-member boards will be, not all 9 board members will be on each informal settlement conference.
No.
You're saying one or more, not a quorum of the board members, may be available to appear at a particular informal settlement conference.
Right, exactly. That instead of just a couple of board members being able to be called, any of them that we need, we can call.
But that's
So that
mostly,
more conferences could be held in a given period of time. Okay.
but that's not a part of the rule change. That's just like an internal structure or an internal policy that y'all are working with the other boards to develop, right?
Correct.
Okay, so if I understand, like that we BHEC received, I think, if I understand correctly, over 100 comments against this rule change. And it seems like people were mostly concerned about just the idea of staff handling these complaints of professional members not hearing this. And I don't know if y'all want to add more to that, if you want to kind of maybe summarize that better than I can. But one of the questions I have is, would it be possible, would it be possible for the respondent to opt to have a board member on their ISC? Like, would we be able to give them the choice? Like, basically, either staff can hear it and we can settle this really quickly, or if you want to take the longer path, we can involve a professional member. Like, it would be possible to give them the option?
So that's certainly something, an idea we can look at and bring to the council meeting um, in February to discuss if there's a tweak to the process or the rule that would make it more palatable. Yes, you're correct. We had about 250 comments opposed to it. The overall input was yes, they felt that if it was a question of standards of practice or ethics, that you needed to have a professional board member specifically present to judge that violation of those standards, which we don't disagree. And again, that's our whole point is if it requires professional judgment, we would hold an ISC with a board member. Now that's where that may come in is, and we'll have to deal with is if we disagree whether there's a matter of professional judgment that matters to the case. But that's certainly something we could work on clarifying.
Would it be, and again, this is just me throwing out ideas, but like would it be possible, or maybe should we or could we change the rule to make that more clear that it's not that like board members will never be included, but that board members can be included if there is an ethical or practice violation?
You can certainly look at that.
Well, I'm looking at it and it says agency staff may solicit input from and request the assistance of board members if there are concerns about standard of care, scope of practice, or ethical practice shown by a licensee. So that to me says staff can hold their own ISE and adjudicate the complaint without a board member if it's expedient to do so and doesn't address any of those three areas. If it doesn't address those areas and there's a question where board member opinion is needed, then staff would call us in. Is that the correct understanding of it?
Well, I want to clarify just a word that you used, Dr. Elder, which was adjudicate the complaint. And I think it's important, you maybe didn't mean it in the way that I'm hearing it, but when you say
A
adjudicate,
legal term. I don't know. I don't know.
you're making a final determination. And I think it's really important to note what is an ISC, because I think some of the problem too is some of the people who's concerned about or commenting about the rule is a misconception about what exactly the ISC is or is for. And the ISC is not an adjudication of the complaint, right? The final adjudication of the complaint is made by this board making a recommendation, this full board, right? Whoever wasn't a part of the ISC, but looking at the complaint and the matter that was litigated at SOA, and then it goes to the council and they look at your recommendation as the board to enter the final order on it. And that's the actual adjudication. That's the final decision. That's the point where they've made a determination of fact and law. And so the ISC is really just, it is a informal meeting where you sit down with the complainant, you sit down with the licensee separately, and then you have a discussion with them and you try to understand their perspective and whether or not the people there in the room, staff and or the board members present think, okay, a violation may have occurred or may not have occurred, and how best to go forward with this, but it's not a final determination of anything. And so it's an attempt to potentially resolve something in an informal way, but it's not a binding, a required thing. And technically under the rule, the licensee is not legally required to show up to the ISC. They don't have to be there. So we can proceed beyond, they have to be given that opportunity. So it is a very informal, in the name itself, informal procedure. But it's a requisite for us to move the complaint forward, because under the Administrative Procedures Act, you have to give an opportunity like this to a licensee before further disciplinary proceedings can go forward. So when you say adjudication, it's like, whoa, that's way down the line. This is like a very preliminary, just an attempt to resolve or settle something. And that's why the amount of involvement and who's involved in this, it's most important for you as the board members to sit and actually adjudicate this, yes, as the full board when you review this. Does that make sense? I'm sorry, it
That's
went
an
in my
area.
soapbox, but yeah.
Yeah, but that's an area we could also potentially do better at communicating to the licensees when they're coming to the ISCs, that to make sure they understand this is a informal option conference where you can agree or disagree. You're under no obligations to settle with us.
Is that the same as an informal hearing?
An informal
Ish.
hearing, I don't, I'm not really sure, like, what do you mean? When you say informal hearing, like, it's really not necessarily a hearing. It's just because there's not a hard and fast structure to it. You don't have to call witnesses or anything like that. It's really just, honestly, you can sit down at a Zoom and just have a conversation and say, what's your side of the story? Tell me what it is. Why do you think this did or didn't happen? It's really not formal at all. The formal actual hearing is when it goes to the State Office of Administrative Hearings.
Oh, no, I meant informal.
Oh, informal. I mean, yeah, I guess so. Yeah.
Any other questions? Conversation. Go ahead, Dr. Merchant.
I have another question. Like if BHAC were to adopt this rule, I know, I mean, like on the MFT side, I don't know, maybe it wouldn't affect MFT as much because I really like being a part of informal settlement conferences. I think Dr. Elder does too. And I don't want to lose that. I also, I don't know, I just think it's good for us. I think I enjoy us being a part of that process. Um, I also don't want to lose the oversight function, and I think that maybe MFT does a little bit more in terms of like oversight of even of like agreed orders and things because, we meet every quarter and kind of review what staff has done. And I don't know that other boards do that. So I guess one of the things I like, I mean, how are other boards going to continue to have oversight over this process? I guess is one of my questions. Does that make sense?
Sure, and that's part of it is the tension that happens between what is the formal rule language and what is the practice of the agency. Um, it- there certainly we are relying a fair amount on you as the board to trust us as staff to make good judgments about when we need to involve you and when we don't. You can have that. You can have more formal oversight by putting in structures, by putting in language like the staff shall. Uh, I think you probably noticed that the sentence Dr. Elder read is the staff may
Mhm.
solicit, and we are telling you and will represent that we always will if there is a standard of practice. But we didn't use the word shall because then we are bound to that and must every time, regardless of the circumstances. And given the increase in complaints that Patrick is referenced, we are trying to give ourselves as many tools as possible to move things along. So yes, there is an element of trust in this that you are trusting that we are making good judgments. I do think the LPC board is interested in having some level of quarterly reporting in the way, not fully to the extent your committee does, but in a similar vein of getting those updates. Um,
Okay.
yeah, that's what
And
I can say.
Patrick.
yeah, if I can add to what Robert was speaking about is in that same sort of aspect is currently, if you look at so what we're talking about are the complaints that make it to an ISC, but oftentimes there are complaints that either get dismissed before an ISC or there are complaints that get resolved with an agreed order before an ISC. And oftentimes those aren't necessarily reviewed by a board member. Those are taken care of under the current rules under BHAG. But as you asked, what's the accounting? What's there still is. That's why in the board packet we put here's all the cases we dismissed. Here's all the cases that we resolved with agreed orders. Some of them are post ISC and some of them are pre ISC, but we still report all those things. So if there is something where a board wants to do some sort of particular oversight and something that's some in whichever facet, right? That's something that the board can implement. So
Okay. I just want to, if it's okay with the other board members, I just want to summarize really quick and then ask the board for any other input. Um, and then as the BHAC representative, I would just really love to know what the board thinks. Like, do they feel like this would be a worthwhile, like, I don't know, just should we vote yay or nay? I would also love if, oh, wait, oh, no,
but
we can't do that.
yeah, well, it's not an agenda item for it's something you can certainly discuss, but it's not an agenda
Yes,
item
we're right.
for action. So it's not something you should be
No.
on.
Yeah,
Yeah.
totally agree. I just want to know how the board feels about it. If that's okay, just discussion about that. And then if possible, and if it's okay with Dr. Elder, I would love to see if there's anybody in the public who has an opinion on this and see if there's anything that they would like to share about that. But before I do that, so this is just to make sure that we're all on the same page. Basically, this rule would allow staff to do just almost like put into writing something that's already kind of happening, which is staff being able to do these informal settlement conferences without a professional member when the issue is relatively straightforward and does not involve like ethics or standards of practice. In those cases, when it's ethics or standards of practice and is not clear, then staff will continue to involve professional members. There's still going to be oversight because boards will still have these agreed orders and things in all of our packets. Plus, at least on the MFT board, the ethics committee will still meet and review these cases. And the whole kind of purpose of this is just to make it more efficient, so that it doesn't take, 6 months or a year and a half to resolve complaints. It's to help move things forward more quickly. Did I summarize that appropriately or accurately? Okay.
Yes.
Um, Board members, is there any questions you have? Do you have a strong feeling one way or the other, concerns? James?
You guys might have shared this, but I might have missed it. How many? I heard you say that there's not as many in the MFT board. What kind of number does this look like for us?
For the rest of the agency, like what were the numbers for the rest of the agency or just for the MFT board?
Just for the MFT board, how many? Just what does that number
I,
look
I
like?
mean, we have maybe like 3 ISCs a quarter. So we have maybe 12, 9 or 12 a year that we hear, which is manageable. Like that's not excessive, I don't think.
Yeah, I think it's hard. I don't know the MFT numbers off the top of my head. Maybe Robert's gonna look them up. But I think one of the things we saw from a council level is we're hovering about around 500 complaints that were from all the boards, and it's now jumped almost to the 800 level. And we are seeing just a massive increase of complaints for all licensee types. So we are doing other things, we've hired more staff to try to address some of this, but some of the other things we've looked at is what can we do from a process standpoint? And so some of the places where there's potential slowdown. So that's why this is a all board wide kind of change, not one board specific.
Yeah, looking at the overall numbers, again, Patrick's right. We've got about 800 pending. Um, Only 54 at the last quarter were pending for MFT, and about, oh, 15 to 20 come in each quarter for MFT compared to we get 150 each quarter for LPC, and we have 400 pending. So a significant difference.
Just to weigh in on kind of my feeling of it, Dr. Merchant, you're correct. I do enjoy serving on the informal settlement conferences. I think part of our function as board members is to protect the public, and I see us fulfilling that role by looking at ethical violations and making sure they are resolved in ways that protect the public. I also understand this tension between we do not want to go back to where we were pre-BHEC, where we had this astronomical wait time for resolution of complaints. That's also not good for the public and it's not good for licensees. So I'm all about making it efficient. And I like this kind of list of concerns that would definitely, well, most likely, because the word is may, not shall, but would most likely involve a board member. I like that it's standard of care, scope of practice, and ethical practice. That allows the board, the staff to be free to kind of process complaints that they can process without our input, but also knock on our door and call us into the conversation when our input is needed. So it's uncomfortable to have it be a little more removed, but I also feel like given the current increase in complaints, it seems warranted at this time.
To answer
Any other comment?
Mr. Castro's question, this is in your enforcement report, and the green is the MFT in comparison to the other boards per quarter.
Thank you, Sarah. Are there any other comments or questions from the board members?
I was just going to say, I think everything that we've been trying to do since I've started on the board as a public member is to make things more efficient. Moving to a platform that allows them to put their information in, updating the website, getting information out, like Dr. Elder said, protecting the public. I think anything we can do to make it more efficient is in the best interest of everyone.
Any other board members, especially maybe our public members?
Agree.
Okay.
Yeah, nothing specific to add. I think just with clear guidance on when it falls into that type of situation, I think it makes a lot of sense to help expedite the process.
Okay. Okay, Dr. Elder, are you okay if we open it to public comment, see if there's anybody in the audience
Please,
who would like to share their opinion?
particularly since we had such a robust response with public comment, I would certainly want anyone who's present virtually to have a chance to speak up.
So if you'd like to share your input about 884.11, the proposed rule, please use the raised hand feature. It's at the bottom of your screen. I see no raised hands. I see no one attending by telephone.
Okay.
Okay, then.
Dr. Merchant, do you feel like you have what you need from the board in order to represent us at the big BHEC discussion on this issue?
I do. Thank y'all very much. I appreciate it.
And one other item I just mentioned, there will not only be a robust discussion of this at the BHEC meeting because of all the public comments. The council also received a rule petition that essentially proposes going the opposite direction and requiring a professional board member for ISCs. So that will also be on the agenda at the same time. So again, a robust discussion will occur.
All right. Well, Dr. Merchant, I hope you enjoy that, and Mr. Hampton as well, as you'll both be present for that. So enjoy, and we can't wait to hear how it goes. All right. Anything else under the board administrator report at this time? All right. Thank you all for your participation. We're moving on to item D, which is reports from committees. Our first committee is a report from the Ethics Committee, and I'm the chair of that, so I will provide my report at this time. I first want to say thank you to the staff for preparing the files. These are incredibly detailed files on the ethical complaints that come through. They're big files, and I want to say thank you to the board members, both public and professional, who serve in that capacity, because it takes quite a bit of time to review all that material to make a sound decision about the issues. So thank you for the time and energy that goes into that. The Ethics Committee met on January 7th. We reviewed 11 cases that had already been through the process. And we were basically going back and reviewing, saying, okay, do we agree with the decisions that were made? And in that case, in all 11, we agreed with the decisions. There was one warning letter issued. There were 3 reprimands. There were 6 dismissals and 1 probated suspension. And when board members reviewed those, everyone was in agreement. The only kind of tweaks to the process moving forward were that we wanted to be sure that peer consultation was on the table as a possible part of the sanction process, because there's so much value that comes with that. If we don't feel like the violation warranted a ongoing supervision, ongoing peer consultation might provide some oversight. And then also, we wanted to be clear that we as board members, as we're processing complaints, can stipulate that a licensee can no longer work with a specific population. So because of the violation, this person can no longer work with children, or this person can no longer work with women. Whatever that looks like, that can be part of the agreed order. Ms. Richardson, did you have something you want to add to that?
Yes, thank you, Dr. Elder. I was actually going to just ask if Mr. Hyde or Mr. Rumig could, just for the purposes of like anybody listening, comment or elaborate on what reprimand really means to a licensee once they've been once it's been settled that way.
A reprimand is the lowest level of disciplinary action, but it's a formal discipline, and so it would be if it's either an agreed order or a final order from the agency. If it gets litigated through a full contested case, it would be a reprimand that would be on their record. We would have to report it to the National Practitioner Data Bank, and so they would have a reprimand on their published, on our licensing database, and then in that's publicly available to anybody, and in the NPDB indefinitely. So it gives public notice of what that person was reprimanded for, but it's again the lowest level of discipline that we would provide. It can sometimes accompany certain things like requiring them to do continuing education hours administrative fine or something like that. But or you can do a reprimand by itself. So does that help answer your question?
It does, and thank you. I think especially since we had several of those this chunk of time, and we don't often have those. I thought it just might be nice to kind of for anybody who might be listening or who might watch it asynchronously later. What does that really mean to have a reprimand?
Sure, and there is also, I can't remember the rule off the top of my head, but there's a specific rule about the sanction levels, and so it'll start off with reprimand as the lowest, and then it's probated suspension is the next one, full suspension, and then revocation. So it's in the buckets of discipline that you can get for a formal discipline. Reprimand's the lowest level one. So yeah.
And I might add, because I think we do get this question sometimes, um, when somebody gets a disciplinary action of any sort, the board rules, unless your license is revoked, the board rules do not require your employer to take action against you or to fire you. It does not require the insurance companies to drop you off of panels. Unfortunately, we understand that there are some employers who, the minute you get a complaint, they will let you go out of fear of liability, or insurance panels. I personally think that's an overreaction when somebody gets a complaint that hasn't even been finalized yet, and you don't actually look at what is being alleged. But unfortunately, the board has no control over what insurance companies choose to do or what employers choose to do.
All great points. Did you have any other questions or comments, Ms. Richardson?
No, thank you very much.
Sure. Okay, so the next time the Ethics Committee met was the following day on January 8th. At that time, 2 informal settlement conferences were held. One resulted in a dismissal, one resulted in a revocation of the license. What we walked away with was, and just for anyone who's listening asynchronously, if you're a licensed marriage and family therapist supervisor, anytime you sign that supervisory agreement form, you should be reminding the associate that they cannot start to practice, see clients, or do supervision until they have that full license, approval from the board, and that as the supervisor, it is your job to review all marketing materials of your associate to make sure that they are representing themselves and their services accurately, and to make sure that you're reflected as their supervisor, website, marketing materials, informed consent, all of that. And then lastly, if you have an associate who is engaging in coaching for whatever reason, you as the supervisor should be uber clear yourself and with your associate what is the distinction between coaching and the practice of marriage and family therapy and what the boundaries are around that. Would any of the other ethics panelists have anything to add about those meetings? All right, thank you. That concludes the Ethics Committee report, and we'll move on to item 2, which is Licensing Standards Committee. Dr. Merchant.
Yes, so the Licensing Standards Committee met on December 17th. We had one licensing appeal that we heard, and in that case, the committee determined to deny the application. The person, well, we decided to deny the application. I don't know, we need to go into details, but we also at that meeting talked about, very briefly talked about doing some research on hours requirements and how many hours are actually needed in order to have somebody be competent for unlicensed, I'm sorry, not unlicensed, that would be bad, for unsupervised, like full clinical practice. So to be fully licensed. And we didn't get very far. We just kind of threw out some ideas. And so we will meet again in February or March to begin maybe looking into like what some hours research might look like. The last thing that we talked about at the meeting was acceptable documentation for staff processing license applications under 801.115. So like when a licensee is, or when an applicant is licensed in another jurisdiction and they are coming into Texas, from another state, like what is acceptable evidence of meeting statutory requirements? So, kind of like we kind of talked about just the different documents that maybe somebody could produce, to let us know that they had met the statutory requirements in terms of like hours, supervision hours, length of time, all those kinds of things. And then the last thing is not at the meeting, but just between the meetings, I approved two study plans of people who were applying to take the licensing exam for more than the third time. So, any questions about any of that? Okay.
All right. Thank you, Dr. Merchant. Moving on, the next report will be from the Outreach Committee Chair, and that again, you're on.
Okay. So the outreach committee, we met basically to review the findings of the supervisory survey. You have a copy of some of the results that we reviewed. I don't know. I guess, well, I'm not entirely sure the best way to proceed here. Let me just, I guess, start with this. Well, let me just start with this. Were y'all able to read through kind of some of our results? And do you have any questions? Or would you like for me to kind of give you a summary of the supervisee survey, kind of what we found? Like, how would it be best for me to proceed at this part?
My thoughts were is this the same as item 10 on the agenda?
It is.
Okay. So then
Or I
do
can
we
save
want,
it for item 10, but I mean, I guess the short story, and then we can go into more detail if you want. The short story is the supervisee survey was tremendously successful. I think that we were able to find some kind of interesting information. Our next step, though, is to do a supervisor survey, and survey supervisors to see kind of like how their experience maybe is similar or different or mirrors that of the supervisees. And then after we have done both surveys, figure out if there's any kind of rules that we need to create to or remove or amend or just kind of see what we need to do in terms of regulation just to make sure that supervision is successful for both supervisors and supervisees. And so that's kind of like that's the short story is that we've analyzed some of the results. Now we're going to do a supervisor survey, and then hopefully by September we'll maybe have bringing something to the board perhaps then. But if you would like for me to talk to y'all either about the survey or talk to y'all about kind of the results of the survey, I'm happy to do that, whatever the board would like.
It seems like we've already got that on the agenda for number 10. So I think a more in-depth discussion seems like it's
Yeah.
kind of, right?
Yeah.
Okay.
okay, great. Dr. Merchant, did you have anything else to add on this committee?
I do not.
Okay, then we'll move on. Item 4, report from the Professional Development Committee, Dr. Barti.
Yes, the Professional Development Committee also met on the December 17th. I'm the chair. I was not able to be there, so I believe that Dr. Merchant, you took over. So can I pass that on to you for yet
Sure.
once again to have
Yes.
your summarizations of the goings on? Thank you.
Yeah. I do would like also there does need to be some kind of discussion here. Basically, in the Professional Development Committee, we looked at the proposed CE rule. So just as a reminder, we did a CE survey last year, and then we took the results of that and we created what I presented to y'all last time, which was our quote unquote radical plan on how we would could potentially revise our CE rule to make it simpler for licensees and for staff. And so Robert and Patrick worked their magic, and they basically have created a proposed CE rule based on the recommendations from the Radical Plan. I would like basically y'all's feedback about the Radical Plan or about the proposed CE rule and what y'all think, if you like it or don't like it, or just if there's any changes or things that you would suggest. And if y'all are in agreement, then the next step would be for me to go to the other boards and get their feedback on it. Because the MFT board should not change the CE rule and make it radically different from all the other boards. Like if we're going to change the CE rule, then it needs to be standardized. Like we all need to be on board with it. So if y'all are okay with this kind of proposal, then the next step will be to kind of go to the other boards and try to get them on board as well. Ms. Richardson?
I read through it and I had a couple of questions. How many hours can people get from self-study? That wasn't clear to me when I was reading through it. Maybe I just missed it. Maybe I was going too quickly, but that was not clear to me how many hours you could get from self-study.
Up to 10.
Up to 10. Okay. So maybe I just went too fast. My follow-up question to that is with things like self-study and things that you're sort of doing by things that you are doing by yourself. How do stakeholders document that with CE Broker? Do you make your own certificate? Do you check a box? How are we inviting them to document this?
So currently, if it is pure self-study, um, and because it is only a one hour credit, I think, right now under the rule, we don't require any documentation. Just I'm reporting self-study. For the other things, though, it's usually we just tell folks do what is logical. If you wrote an article, attach the article. If you taught a university course, attach the syllabus. Attach a letter asking you to teach the CE course you taught. Just anything that would show this is what I did and how that would work. So the plan is expanding that to 10 hours and expanding the what we're calling non-credentialed CE. And the whole point is that it doesn't come with a certificate. That's why there's no certificate there.
Does it make sense to include examples then in the rule? Because I feel like when we switched to, for example, when we switched to a system where we were no longer, the BHEC and none of the boards were credentialing CE providers, we started to have language in our rules about, well, then how do you know who is appropriate to get? So we had examples. That was quite the kerfluffle. And I am imagining that people are going to be anxious about reporting self-study and giving themselves credit for self-study when they have absolutely no idea how to document said self-study.
I don't think we would want to put the examples in the rule language itself,
Okay.
but I do think that is something that could be explored. I think a conversation, when it gets to the point of proposing the rule, I think one of the questions that we discussed with Dr. Merchant and I think y'all discussed previously is if if we're not going to require documentation of these 10 hours, do you continue to want to require these 10 hours at all? And there was some desire that yes, it is valuable. But so how does one do that? I think another thing we can do is talk to CE Broker about including example language when they are reporting. If they select, self-study, it could say, please attach some, and give examples, things like that.
I think that could be a great alternative because that's mostly how people are going to be interacting with the system, right? They're after reading the rule and trying to be in compliance, then they're going to go to CE Broker and try to like upload everything. I think that's a great idea.
Any other questions or feedback?
Me, if that's all right. Okay, so I really appreciate the fact that there are examples under the self-study item like articles, podcasts, videos, but also peer consultation, case staffings. I've heard lots of feedback from clinicians saying, I find that some of the most valuable work that I do clinically, and it doesn't count toward my CE. So I'm super excited that that flexibility is in there so that that can be included and counted now. I'm okay with the honor system where, they go in and say, I did a case staffing with so-and-so, and they can report it online and it's all the honor system. It's 10 hours. I think, I hesitate to say it out loud, but I think it's okay. We're getting rid of the 50% rule. I think it was confusing. I think it was overwhelming. And I don't think we're going to have a lot of arguments from clinicians saying, no, put that back in. My one question, I have two concerns or questions. One is It looks like we've removed the ability to carry hours over from one renewal, like excess CE hours from one period to another. And I'm curious what the committee's reasoning was for that. And second of all, other boards require the JP exam for renewal, not just for supervisors, but for any license renewal. And we're not doing that. It's an option, but it's not required. And so I'm curious about the rationale behind that as well.
I will say, to the first question about the 10 hours not being able to carry over to the next renewal period, that's relatively new for the MFT board. I think social work has maybe been doing that for a while. And whenever we standardized, like we adopted that rule from social work. I will say part of the problem is logistical in terms of CE broker. If you want the hours to count, like if you want the hours to roll over, then you're going to have to make sure that you input them into CE broker last, because it will not take them if you enter them first. And so just in terms of logistics, and making things easy, I don't know, Robert or Patrick, do you want to say anything more about that?
Yeah, it was partly looking at this in an overall package of streamlining the rule, and if you were going to really take a radical approach, um, the added complication of people getting disgruntled because they can't carry over what they wanted to carry over felt like it undermined the value, especially if you are increasing the number of non-credentialed hours to be more flexible, if you're getting rid of the 50% rule. Do you, I think it came back to we we would recommend as staff, you as the board really think about how much training in a renewal cycle do you want them to have and in what? And let's require that and not say, well, you have to get this many hours, but not if on a Tuesday you took this particular class and then you get this special rule. Like, let's just make it very clear this is what's required.
And I think simpler is always better. I mean, from the very beginning, I think every licensed professional has had excess hours over the 2 year. I mean, if you go to a conference, you're going to pick up 20, 25 hours. If you go to a conference in 2 years, you got 50 hours. I mean, there's always been excess. And I think trying to keep it simple and just say, let's do this. You're going to get the extra training that you need. Good. This is what the license requires, but this is what your professional identity might benefit from. And so just keeping it as simple as possible, I think is a good way to go.
And then I don't know that I have an answer to your second question about the jurisprudence exam. I mean, I think LPC maybe requires, I don't know if all three boards require the LPC exam.
Only
I
LPC
mean,
requires it for everyone,
yeah.
and the others required if you're a supervisor, I believe, or social work does. I don't think psychology doesn't require it for anyone in particular. Um, that's just a decision up to the board. There are certainly arguments that once you've taken it once, uh, what do you really need to show it again? On the other hand, it is a no-fail, fairly easy process, and so there are arguments that, well, once every 2 years, it serves as a way to refresh you on the rules. So,
I,
you know,
yeah, and I would be in favor of it because of the dynamic nature of statutes, rules over a 2 year period. I mean, we're talking about some changes and requiring everybody to kind of be aware of that and to be accountable for that. I'm a fan of it. I think it would be a good thing just because of the dynamic nature of it.
I'm I like the idea of it. I don't like the cost of it. Um, I think that would be my hesitancy is requiring them to do some, to me, it's like an additional licensing cost now if we're telling them, I don't know. That would be my hesitancy. It's just the expense. If it was cheaper, maybe.
Who sets the rate for that?
Vendor.
we set the rate, although the bulk of the fee is passed through to eStrategy, who runs it. And so we can't, I think we only set it maybe $5 higher than the lowest it can possibly go. So we can't lower it really any further. Um, and I think it's a fair consideration. What I would say, and I don't know the answer to this, is how much does an hour of CE usually cost? Because $39 doesn't strike me as a high cost for a 1 hour lunch CE, but then again, maybe folks get free. This is y'all's business, not mine. So I don't know.
Sarah, do we know how long it takes most people to do the CE or to do the jurisprudence exam? I ask because comments are always like, it took me 3 hours. And it's like, I'm just curious if we have an estimate of how long it actually takes people in general.
The the vendor doesn't actually track that. A person can stop and start. They can leave it on Tuesday and come back to it on Thursday. And so it doesn't, they don't really track that duration. I've not gone through the exam myself. It's on my to-do list to check out a few things with the user interface. I think the last time that I went through it, it took me about an hour and a half, but I'm pretty well versed on where to find what language in the rules. So that's not a fair comparison. And I'm looking at, different things on the screen than just the questions and the answers. So I'm sorry, a fuzzy answer. A thought that occurs to me just for the board's consideration, the MFT board has a lower number of complaints while not requiring everyone to complete the jurisprudence exam. And the LPC board has among the highest number of complaints while requiring everyone to complete the jurisprudence exam. So it may be a good idea in theory to keep everyone up to date on the rules, but I'm not sure you're getting the outcome you might be hoping for with the requirement.
That's a good point, Sarah. Thank you. Okay, any further discussion about the CE rule?
I'm in favor, I'm with Dr. Barty. I'm in favor of requiring it. I just think it's a foolproof. They can't fail it. I really think we should be requiring people to do some type of demonstration of their knowledge of rule changes because it does change a lot over 2 years. If you want to renew and stay licensed in the state, show us that you've done something to keep up with the rules. I mean, and you could argue, well, we're requiring 3 hours of ethics, and you would assume there's some rules in there, but not necessarily at times. So,
Yeah, I'm just curious about the dynamic you mentioned earlier, Dr. Merchant. That is, BHEC is trying to get all the boards to be the same, some of these areas. And if we held off on this one, which is kind of a low hanging fruit kind of thing, it's like, what's the holdup, y'all? So
Yeah.
seems
Well,
pretty clear.
if things work out the way I want it to, then I would try to pitch this to the other boards between now and probably May. And then maybe over the summer, hold some town halls with licensees to kind of get their opinions on the rule, and then maybe be ready to start proposing rules sometime in the fall. But we'll see if things work out like that.
Another question. So if we did say yes, do we get to decide how many hours, credits, CEs that one would get? Or would it have to be exactly like the other boards?
Ideally would be, I mean, the hope, this is more because, well, okay. Like right now our rules aren't standardized. I mean, LPC requires 24, LMFT and social work require 30, psychology requires 40. So I think, again, in an ideal perfect world, we would probably all have to share the same number of like total hours. But I have a feeling that that might not be how this works out. I don't know that LPC is going to want to bump up to 30. I don't think that the MFT wants to bump down to 24. I know that social work is going to want to bump down to 24. I definitely don't think that psychology is going to want to move. So I have a feeling that boards might still continue to choose slightly different ratios. in terms of like their total number of hours and how many of ethics or how many of, uh, a specific population. So I think that there might still continue to be some variation among the boards, but that kind of, I don't know, we'll have to see how that works out.
Okay.
Dr. Merchant, do you have what you need from us as a board to move forward with this radical plan?
I do. It sounds to me like y'all are okay with kind of this rule language. And so if y'all are okay with this rule language, then I'll move forward with approaching the other boards to kind of see how they feel about it.
They renew every year.
Every other year, every 2 years.
Okay.
Thank you to this committee for your work on this radical plan, particularly Dr. Elder. I think I'm Dr. Merchant. I think this has been a big lift for you. So thank you for your work on this. All right. And our last committee report would be the Rules Committee, Mrs. Richardson.
Yes, so we're only able to meet once since our last board meeting, and the nuts and bolts of our meeting included we are going to need to change the language in our rules about about the definition of technology assisted services. Right now, the definition is far too narrow. And so what our committee met and kind of talked about is like exactly where to hone in next. And I think that's sort of step one, is paying attention to that specific rule. And then perhaps later we will have more specific language that includes AI and other technology assisted services other than just telehealth.
Any questions?
May I add something? And then I also have a question. Anyways, so the add is that I think if we are able to move forward with our CE rule, part of what we will do when we move forward that CE rule is hopefully change the definition of TAS at the same time to make TAS more inclusive of things like AI, because right now it just is so narrow and it just basically includes telehealth. So that might be, again, also perhaps happening like September-ish or in the fall. And then one of the questions that I had is for the Rules Committee is AAMFT has published a new code of ethics. I'll be honest, I haven't had a chance to review it yet, but I'm wondering if maybe that's like, would the Rules Committee or another committee want to review the new AAMFT code of ethics and just see if anything in there strikes us as maybe needing something that we need to do differently on our end too? I don't know.
I'll add, I reviewed that new code of ethics. A lot of it's wordsmithing. I don't think it really intent of a lot of the rules, but I like where you're going with this of like, if there are any changes that we need to incorporate, I support the Rules Committee looking at that.
What do you think, Ms. Richardson?
I completely agree. I'm just making a note to go look that up later. Yes, thank you.
Cool. Okay. Thank you.
All right. Anything else for our committee reports? Okay, moving on. Item 5 on the agenda is discussion and possible action to re-elect or replace our professional member delegate to the BHEC board. And currently, Dr. Merchant is our professional member delegate, and I open the floor for nominations.
This is Elvira Reina, and I move to re-elect Madam Chair Lisa Merchant to the Executive Council.
Dadgummit, you beat me to it, Elvira. Dr. Marti, I'd like to second that.
All right, so any discussion?
Thank you, and I accept the nomination.
Perfect. We were hoping you would. All right. So all in favor of the motion to re-nominate Dr. Lisa Merchant as our professional member delegate to BHEC, signify with aye.
Aye.
Any opposed? Motion passes unanimously. Thank you for your willingness to serve. All right, item 6 is licensing matters. I don't believe we have anything that needs to be addressed under that agenda item. Ms. Basholtz, is there anything I'm missing here?
You're correct.
Okay. Item 7 is examination matters. And we were provided with the JP exam reports, basically feedback that included comments And I want to open that up to see if board members have any comments or questions about that.
There was one concern that somebody wrote about a question being confusing, and I wondered if maybe just adding a comma would be helpful to making that question a little less confusing. But I can email that to you, Sarah, if you would like.
Okay. Please.
I also wanted to ask, maybe I need some more context here, but there was a comment about Ms. Fasholtz, you having to go in and update the links every time the rules change because the Secretary of State creates a new web page with new links. That is time intensive. Is there any way for you to not have to do that every time?
Not that I have found.
Ugh. Okay, well, thank you for your work because that is quite tedious and time intensive. Okay. And I just want to say thank you for your responsiveness because there was like one question where people said, I think it should be false. And you submitted that and got it changed really quickly. So thank you again.
I'll also add that I love that Sarah even reached out to a couple of people and gave them a response to the feedback they left. And so that's just really good customer service. So thank you for doing that.
Absolutely.
Agreed. All right. Anything else on the JP exam? All right. Agenda item 8, which is enforcement matters. The board members received 6 agreed orders. And before we move on to the SOA case, I just want to open that up to see if there are any questions or comments. Okay, hearing none, we'll move on to item A, which is the State Office of Administrative Hearings, the proposal for decision and final order in the matter of Christopher O'Neill Jones.
And if I could help Dr. Elder just provide a little background. If you do remember back in the May meeting, he was an applicant that was reviewed by the board. He had several degrees, but the board had determined that they were not marriage and family therapy degrees, and he didn't have an internship. And so the vote was to deny his application. He appealed that decision to SOA, and so a SOA hearing was held. In your packet is the SOA record as well as the proposal for decision. And in that proposal for decision, the administrative law judge agreed, found that he did not have the requisite degree or internship required for an LMFT associate license. And so staff is recommending adopting that proposal for decision and denying the application. So the recommendation would be to approve the PFD. There's a proposed order for the board's consideration and recommendation. And that this recommendation would then go to the council at its February meeting to enter the final order. So we did also notify the applicant that the board would be reviewing this matter and invited him the opportunity to address the board if he would like to.
Ms. Fasholtz, is Mr. Jones in the
Yes
on the call? Okay. Do we want to invite him in to see what he'd like to add to the conversation?
Mr. Jones, can you unmute?
All right, I'm unmuted. Can you hear me?
Yes, sir.
All right, are you able to see me?
No, but that's the protocol in this venue.
Okay. All right. I was okay, so I did have a couple of screens that I wanted to share with you, so I would just try to describe what I'm seeing. Well, thank you guys again for an opportunity to appear before you. I just want to take these 10 minutes just to state that when I appeared the first time, there were certain things I did not understand. It was a matter of just discussing. And so when I did appeal my decision, I went to court not knowing it was as formal. And so my reading of the decision was I argued a very strong case, but evidence was not there. And so it was being sent back to you for final decision. The judge ruled that there was not enough evidence to state that you guys had made a mistake in your interpretation. And so I'm here I guess kind of as a last appeal, I understand that the likelihood of you reversing course is not high, but I want to be able to communicate a few things to you. The first thing is it all boils down to, is receiving a Master's of Divinity engaging in assisting individuals with direct services? During the hearing, it was acknowledged that that is the case. During my initial conversation with you, that was not acknowledged. It was somewhat split. And so some of the statements that were made equated a pastoral counselor with a life coach. And there was also refutation of that. But what concerns me was one of the last two remarks that were made. One of them was that a person on the board is married to a priest. And although that priest does a lot of good work, that work does not amount to that of that person. And my statement was, does your priest husband have the credentials that I have? And when I rattled off some of the credentials, among those were my residency, which was a 2,000-hour residency, in which 1,000 of those hours was in direct clinical services. That would include 400 of those hours. 1,400 of those hours were in direct clinical services. 400 of those 1,400 would be with couples, and roughly 1,000 would be with individuals in the VA hospital. I also reiterated some of my transcript hours. And a remark that I don't know if it was literal or just in jest was made: could we change our decision? Now, during my appearance before you, some things were stated that caused me to be a little concerned that I'm not sure if I'm being heard. Things of, if you voted yes for me, it could potentially open up the floodgates. There's a problem there. I have quite a few hours that I'll be able to demonstrate. And if persons came to you with the same credentials that I have, I don't think it's going to be a floodgate moment. And also, I don't know of too many people that will be willing to come before you, argue a case, lose, go to court, argue a case, lose, and then come before you again to argue the same case. I think that your checks and balancing system is actually working quite well. And I also believe that you made a good decision not doing what the LPC did, which states that a theological degree is not to be considered as an equivalent degree to like of an MFT. And the reason is, since COVID, many divinity schools have realized that there is a huge market for actual therapists. My degree was granted in 2006. Things have changed drastically since then. Remember, around that time, we were having faith-based initiatives by George Bush. And so seminaries were beginning moving towards stating clergy are not just preachers, they're not just hospital workers, but some of them work with depressed persons experiencing substance abuse, as well as couples. Now, Princeton, being Princeton, was ahead of many institutions. And so it was implementing a program. It was somewhat a test. And so we had a lot of courses that we could take. And Princeton's pastoral counseling department was successful in arguing that we would like for students to be able to take 12 to 30 hours. And so they fought to allow for that to happen, whereas prior, many courses were more church history, biblical studies, languages, and proper theology courses like systematic theology, such as the doctrine of God. But because of the work that was being done at Princeton, that has opened up the door for many theological institutions to offer similar courses for persons who have worked careers in actual therapy, I was quite trained. And so what happened is it was stated that I only have 12 hours. Now, these 12-hour courses would be pastor's person, which is basically the orientation to how you can engage in pastoral counseling in every area, whether it's premarital counseling, depression, addiction. It was like a survey. So that's basically a theoretical foundation. Also, the self in the system, which was an analysis of systems theory, sexuality in the Christian body, which was how do we address sexual dysfunction and sexual norms from a therapeutic standpoint, and then addiction and grace, which looked at the medical model as well as the choice model of addiction. And it stated that the grace model that Princeton was espousing is identical to the medical model. So how do you help persons become sober? And so the ideal was those directly labeled pastoral counseling courses are the only courses that I have. And so I have a visual that I can't show you, but the visual basically states if it's 12 hours out of 60, then that's a very low ratio. You're correct. I actually don't qualify. But you have to remember, my degree is pre-2017. So that would be 12 hours out of 45. So that's slightly more than 25% of the courses. And I would actually still agree with you. I don't qualify. Because if I've only done 25% of the curriculum, that's kind of like a minor, not a major. So it's not sufficient. And something that I think I remember hearing is that if he had 50%, we might be willing to consider it. But here's the problem. When I was trying to explain things, I stated that I actually have 42 hours from Princeton alone. And if I could just kind of mention these courses, Pastor's Person, which I mentioned, The Self and the System, Sexuality in the Christian Body, Addiction and Grace. But here's another course. It was Pastoral Ecclesiology for Pastors. That particular course said, you're a pastor. What type of pastor are you going to be? Will you be a counselor? Would you be a teacher? Will you be an activist in the community? You had your choice. I chose to be a pastoral counselor. And so in that course, we did extensive reading and role playing, and also went to a hospital where I provided pastoral counseling for clients. Then when we go to the next category, which will be human development, gender, and multicultural issues, the credentials require 6 hours. I have 6 hours. One of my courses is Feminist and Womanist Thought. That is basically a deep dive into how do you perform care to persons who are women. A theologian could just talk about it. But those of us who are pastors took that course to begin to acknowledge the oppressive nature of Christianity and how a lot of subjugation was there. And again, you get to choose how are you going to apply it. Another course was Ethics 324, which was on ethics and politics in a Black community. That particular course, you did the exact same thing. I focused on the harshities that many urban and rural African-American families face, as well as the gender strain between Black women and Black men, and interracial relationships within the Black community. Again, that is preparing directly for clinical hours. You require something in psychopathology, which I did not have a course in that, and I acknowledge that. But you also require 3 hours in ethics, which I have one, Christian social ethics. Again, this is how do you run a ministry ethically in our society, both respecting the rules, the norms, confidentiality, and you just went through a whole host. The only difference is that it was preparing persons, again, for nonprofit leadership, for congregational or parish leadership, working in a hospital setting as a chaplain. So it prepared us for many different areas because, again, they know that not everyone coming to the seminary will become the senior pastor of a church and preach from a pulpit. Then you also have 6 hours required of research methods. My thesis was, you have 3 hours required. My thesis was actually a 6-hour thesis. It was literally 90 pages written. And it was a direct application of how you can create a holistic ministry for African-American couples so that we can challenge some of the sexism from Black men to Black women, as well as the distrust that some Black women held toward Black men, what type of counseling strategies would be there, and how you can also engage in educational counseling so you can help persons use education as an avenue in order to have achievement in advancing. Again, preparing me for direct services. Now,
Mr. Jones,
yes.
I just want to let you know, we've allotted 10 minutes and you have 1 minute remaining.
Okay, thank you. Thank you. And now after that, I also have a 12-month residency that was 40 hours each week minimum. And in that, I performed therapy with couples. All of them were veterans or family members of veterans, as well as persons who were experiencing many type of ailments. And then when you come to the elective, so of Princeton alone, I had 42 hours. But when you include my hours from Toro, since we acknowledge that Frankenstein is allowed, I actually have 93 out of 45 hours. So my statement is if I come with those types of credentials, that's not opening the floodgate, because I doubt that you're going to find a master's level clinician who has over 93 hours of direct courses preparing him for clinical services. So why not just finish my degree at Toro? Because there's 30 more hours remaining to do that. And prior to this deal, I learned that I actually qualified under the old rules. So I stated, why continue to add more work to myself, more expense to my family, when I'm able to state I've done it? I still will have to pass your exams. I still will have to complete another residency. I'm willing to do that. I think that I haven't been heard because I'm somewhat being equated with life coaches as well as general preachers. I'm not. When I graduated, there was not a direct path at the seminary for persons like me. And I also did not know I would become a full time pastoral counselor. But since then, counseling is really big and I found my love. I don't think it's right to ask me to complete another degree, although I'm halfway done with it, just so that I could satisfy the requirement. I think you can be creative and state that this guy is establishing a precedent, and that precedent is not to open up the floodgates, but he has extensive credentials. And that's the reason he was voted through, not because we're stating that an MDiv is the equivalent of an MFT. It's not. But does it have transferable skills? We're preparing you for clinical services. So I just hope that you can hear my heart here and be willing to reconsider. Thank you.
Thank you for your comments. I open it up for the board to discuss.
Mr. Jones, you definitely do have a lot of academic hours behind you, and I applaud you in that, and quite a range of all that. What I'm curious about is you answered my question I was thinking about asking toward the latter part of your statement that infers that your Master of Divinity degree is not intentionally designed to move one toward licensure. It's designed to move someone into pastoral care. Now, working with people does have many different avenues and pathways, and pastoral care and pastoral counseling for sure is needed, necessary, and essential. And there are a lot of crossovers in the trainings that MFTs get for licensure that pastoral counselors also um, uh, can tap into. What I'm curious about, do you have any knowledge as to how many of your cohort, how many of your peers that get a Master's of Divinity that move into pastoral counseling have an expectation or have a pathway to go straight into state licensure as opposed to just staying in the pastorate?
The majority of my graduating class went into hospital chaplaincy or worked as a staff counselor full time for a Presbyterian church. Princeton is a PC Presbyterian USA. And so they had full time positions. And a number of them would attend additional, like not actual degrees, but they would take hours at a place like the University of Pennsylvania or even the Blatt and Peel Institute. So they didn't get additional degrees, but those states would recognize it because of the rigor of Princeton. And like if you were to look at the readings for any of my courses, I think you will find that these readings are pretty superior to some of the MFT courses. And they have additional theological readings so that we can apply it. So it was kind of double work on our end.
Okay.
It was large because you had a large group of women who unfortunately at that time were being discriminated against, and they weren't going to get a senior parish position, but they could be an associate. And that wasn't fair, but it was a large pathway in that direction.
Mr. Hyde?
Yeah, I just wanted to just draw the board's attention. Obviously, ask as many questions as you want to. I just want to draw the board's attention back to the proposal for decision that came from SOA, and I will kind of point you to. They did have their proposed findings of facts and conclusions of law, which is what we're proposing and just adopting outright. In it, one of some of the proposed facts. So obviously you go to SOA and they're there to create the record of facts, and that's what we're basing all of our review off of. And in their proposed findings, they did look and say, so the statutory requirement to get an LMFT or an LMFT associate is you must have a master's or a graduate degree, doctoral degree in marriage and family therapy or a related field. And so one of the findings of fact that the proposal for decision specifically says, it says Mr. Jones' master's degrees, that because he has to actually hold a master's degree in marriage and family therapy or related. It says in number 11, Mr. Jones's master's degrees are not considered degrees in marriage and family therapy or a related field, nor are they substantially equivalent to such degree programs. So as much, I don't want to cut off the discussion, but I do just want to draw back the board's attention. You can look at what the administrative law judge found is that there's certain statutory requirements. Each state is different. Certain states may recognize these those sorts of trainings, and I think that's great and that's fine. The problem is we're constrained by Texas's statutes, and one of the other things also is the statute says there has to be, an internship in marriage and family therapy or an equivalent internship, and that is where finding number 10. Finding of fact number 10, the ALJ also found that Mr. Jones did not complete a graduate internship in marriage and family therapy or an equivalent internship as approved by the council. So the unfortunate thing is the administrative law judge has gone through this and made these sort of findings. And so that's why staff is proposing that we just adopt those because they are statutory requirements. And so I'm not when he was talking about some Frankensteining things, yes, you can add coursework when you have a degree already for that application. The problem is that the administrative law judge did not find that he had a degree. And so therefore you can't bootstrap on more missing coursework from other programs to help meet those board rule requirements. So sorry to interrupt. I just wanted to redirect the board's attention to that, but I'll stop talking and let you guys ask more questions.
Thank you, Mr. Hyde, for that clarification. The baseline fact that there is not a degree in marriage and family therapy or a related field, I think, is kind of the core piece here. So I think it's important to emphasize that no one on the board is saying, Mr. Jones, that you have not done and continue to do important work in changing people's lives. And we thank you for your service and for the efforts you put forward to helping people heal. We are, like Mr. Hyde said, constrained by what is in statute and rule. And the findings of the SOA administrative hearing basically is that we cannot basically provide a license when the requirements have not been met. I would entertain a motion from the board.
I will note that Mr. Jones did have raised his hand. It looks like
I'm sorry. Thank you, Mr. Hyde. Yes, Mr. Jones.
Yeah. And Patrick, I do respect what you're saying, and so it's not a total critique. Being in the hearing and representing myself, the judge actually stated to me, "You made a very compelling case, but you did not present evidence." That's true. Again, I did not know it was formal. I did not know that I had to submit evidence prior. I thought I was going to come and show what I had. So I had a presentation. I had an entire transcript. I literally had syllabi, which is something I was requested. But because I did not supply that 3 days prior, and again, I didn't know it, I received other notifications, but I did not receive that one, that I had to upload those documents. So what you're saying is that it was actually sent back down to you when I'm looking at the reading. And it reads as if there was additional consideration from you, because based off of my argument, not based off of the evidence presented, it seemed plausible. And so it was somewhat being presented back to you for reconsideration, not just a rubber stamp. The judge has agreed, we agreed the first time, so it's declined. It was something else. And so my statement is, my situation is somewhat misunderstood. It's not just a matter of it being a Frankenstein. It's that if you look at the way you're reading it versus the way the classes actually were, it satisfies the statutes because it is direct clinical services that I was prepared for. But persons were looking at my hours, and the crucial fact when we had this conversation is that it was believed that I only had 12. But I've been able to gather syllabi and demonstrate that I have more than 12. I actually have 42 from Princeton alone. And so 42 of 45 is a pretty high percentage. You're over 90% there. You're around 90% there. Whereas 12 of 45 is less than, well, it's right at about 25%. So that's the difference. Is how you initially heard me was that I was considerably below. And even Miss Sarah stated that the MDiv was not declared not to be banned. It was not banned from it, but she stated that my Master's of Divinity was viewed as being insufficient because of my hours, not because of the nature of the courses. And so what I'm trying to demonstrate is that if you actually only look at the pastoral counseling coded courses, but if you look at the other courses, including the ethics courses, which you require ethics courses in other MFT programs, Christian education courses, which is about leading small groups. It's coded differently, but it's the same content that I've received in other places. So I'm just wanting you guys to realize I'm not an attorney and I did not know what I'm doing. I'm telling you the truth. I really blotched this badly. I did badly, and I'm mad at myself. And so I'm really stating, if you just see what I've done, you would realize the standard that I've satisfied is considerably higher. It's considerably higher than what you might realize, but I don't have the money to afford an attorney, and I didn't think it was so formal, and I messed up a great opportunity. So I'm just kind of throwing myself at your mercy saying, if you saw my real credentials to ask me to do another 30 hours when I'm already really qualified, it just bothers me because it's from an MDiv. When a social work person that I would not criticize doesn't have the training that I have, but because it's social work and not ministry, the perception is that it's neutral and not preaching. And I'm therefore at the whim of how someone might interpret a preacher. I'm not a preacher. I'm a pastoral counselor.
Thank you, Mr. Jones. Any other questions or board discussion? Oh, Mr. Hyde.
Yeah, I just wanted to clarify something Mr. Jones said. He is correct. The board does not have to adopt the proposal for decision that that has been sent to you. It's not a rubber stamp. You can change or modify it. But we need to have legal reasons for doing so. There should be something in the record for why we think that the administrative law judge has misapplied the law. But my personal opinion is I don't see that. So yes, the board has some discretion to do something different. Staff is not recommending that right now. So from that perspective, and if it helps, the SOA proceeding, I don't know if the initial judge's order is in the packet, but typically there is usually a scheduling. Actually, I think number 3 is the initial order that's in the material sent over, and it talks about the uploading of the documents and the requirements for when those need to be submitted for exhibits and everything. So the initial scheduling order, number 1 from SOA, addresses some of Mr. Jones's concerns. So those were provided, but yes, if you're not an attorney, it's possibly something that's you're not used to doing or aware of what you're supposed to do.
And board members, you can see item number 5 in the packet is the materials that the board submitted to the SOA judge, the 79 pages, which includes Mr. Jones' transcripts and the course descriptions that staff received and the program guide that staff received. So the judge had the materials that you had when you reviewed it previously.
Dr. Elder, you mind if I add one piece as well?
Go ahead, Mr. Romy. Thanks.
Just because I can certainly resonate with what Mr. Jones is saying about being frustrated and wanting this information and evidence before the board. And I would just want to communicate as far as staff is concerned, even considering all this, like, not holding against you that this information did not get to SOA, taking everything you've said. The ultimate problem is, and it's in the judge's order. He noted that there's no question as a pastor that you would be working with individuals and families and that you were trained to do so, your dedication, and that you chose your greatest possible exposure to learning about these populations. Though Mr. Jones selected every possible counseling course offered, this does not meet the definition of a planned course of study. And so even if one was to consider that a Master's of Divinity as a concept is a mental health related field, for the MFT license particular, it can't simply be generally a related mental health field. It has to be a related mental health field where you had a planned course of study in marriage and family therapy. And just reviewing all of the courses and looking at all the coursework will not change the fact that you were doing this on your own selection. It was not meant to create a course of study to become an MFT.
I see, Mr. Jones, your hand is raised.
Yeah, I cannot disagree with you, Robert. I'm going to be honest. It was not a planned course of study. But I also want you to understand this is 20 years ago. It wouldn't have been.
Sure.
It wouldn't have been. But if you look at this and you say 20 years ago versus 5 years ago, that's the factor. I'm pushing 50 years old. 20 years ago, seminaries were just trying to get preachers to stop condemning people for being, depressed. We were radical, fighting through it. And it was not allowed by our registrar. I know because I was the president of the Association of Black Seminarians. And I was also on a provost team fighting for this to become recognized. Later it was, but it wasn't there. And so in some way, my frustration is very much because of the time that I was coming through seminary. But that's why I did so much extensive training. Now, what was admitted was my Princeton curriculum, and it did not satisfy it because the argument was it was 12 hours. But because I didn't bring any evidence, I couldn't show the syllabi that would have revealed, look at the text that this guy is reading. These are not biblical texts. We're looking at Friedman. We're looking at Freud. We're looking at Boeing. We're going through many of the different scholars that my courses at Turo didn't even touch. And my professors are amazed that I know them. And so what happens is it was not because this was prior to the time when seminaries were preparing people from it. But if you state that it allows for something that's a relevant field with direct services, my argument is that this is direct services. And I'm also stating it does not satisfy, or else I wouldn't have needed to take additional classes. But if you state, if the guy has 42 hours, but we say it's only 12, but it's really 42, does that come close to the 42-hour threshold for pre-2017? And if we look at the additional 42 hours from Toro, is that clinical enough? So in a way, I'm kind of doing double work, which is fine. But I'm going to essentially be asked to do triple work because I came in a time when my particular type of ministry wasn't in vogue and it wasn't respected. Now, this is not discrimination. That is not what I'm implying. But it kind of feels like ageism in a way. It kind of does. Because my degree is so early, and because counseling wasn't respected, and because today there is a huge disrespect of clergy, because you have many quote unquote religious coaches popping up on the scene with a whole lot of psychobabble, which is not at all good therapy. I'm kind of caught in the middle of two very strong forces stating we don't want to open up the floodgates for underprepared people who are only coming in for licensure so that they can get paid. But then there's also counseling is not theological. So why are you guys trying to do so much of it? Because preaching to them doesn't help them as much as working directly with them. So that's my time frame. I don't need the finances because I make an incredible living. But what I need is I'm realizing that persons who cannot afford me go to different places and their families fall apart. But I have a 91% success rate with married couples, keeping them together and helping them move from just existing to thriving. and I want to be able to service other persons. But because I want to support my family a certain way, I have to limit that number. So I'm really doing this only for insurance reimbursement for those clients. This is not a financial gain for me. And I am coming in saying, if you do this, you can state to clergy with MDiv that they have a precedent now. Because my standard literally is saying I have over half of my background in counseling courses, and I have 40 hours elsewhere. You literally can state under the new rules that as an
Mr.
MDiv, we will apply a maximum of 30 hours.
I appreciate your earnest arguments, but for the sake of time, I do want to invite, are there any board members who at this time, Mr. Barti, I see your hand and I'm inviting, is anyone interested in changing this decision or I would entertain a motion? Mr. Barti.
Well, if we're going to go to that, I will forego my comment and I'll entertain a motion that we accept the what do you call it? The conclusions of law? What do we call it? The proposal?
Findings of facts and conclusions of law.
Thank you. I would vote in favor of approving that.
Okay, we have a motion from Mr. Barti. Is there a second?
Ms. Richardson would second that.
Ms. Richardson, second. Any discussion? All in favor of the motion signify with aye.
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 Any opposed? Motion passes unanimously. Thank you, Mr. Jones, for your time and for your continued service to people and humanity.
Thank you. You guys have a great weekend.
Same to you.
Okay, as a response to that, I'm wondering if we want to ask the Rules Committee to look at amending that particular part of our rules where it says related mental health field. And I know that the LPC board has wording that specifically says, I'll read it to you because I looked it up. I want to avoid applicants from being confused or stuck in this quandary that Mr. Jones has been caught in. It says non-counseling related fields include, but are not limited to, sociology, education, administration, dance therapy, and theology. So I'm wondering if we are interested as a board in having the Rules Committee look at perhaps adopting some of that language in our rules.
I think that would be appropriate. I'd be in favor of that.
Okay, so then can we ask the Rules Committee to kind of take this up in your next meeting and see if we could add some clarity to our rules about this? Thank you.
Yes.
All right, that covers item 8, which are enforcement matters. Moving on would be rulemaking. We have several rules that are up for adoption. We have not received any public comment about these rules. And I want to ask the board, are there any particular rules that you want to pull out for discussion? If not, we can just kind of approve them all in one motion. All right.
If there is silence, I would like to make a motion that we adopt all in item 9, those five rules.
I'll second that. Ezel. Oh,
All right. Thank you, Ms. Ezel. Any discussion?
Patrick?
Sarah, do we need to mention the small typo, the typo in the definitions one that we discussed a couple days ago?
That's
Where
right.
it has
Thank
the
you, Patrick. We did
10
have one small typo in 801.102. It's not exactly a typo. We added a word extra. And so, Mr. Barti, if you wouldn't mind amending your motion, in that rule, we were amending the definition of a license to include the new temporary license that y'all created. But we added temporary to both the regular license and the associate license. We just got ahead of ourselves, and there is no temporary associate license. That does not exist. And so we would just want to strike that second temporary. We don't need that in there.
Was that item 16?
Correct.
I would be pleased to amend my proposal to say that we accept everything as presented, with the exception of striking the item 16, that the second "or temporary" wording.
So Mr. Barty has accepted a friendly amendment. Is there any discussion? All right, all in favor of approving or adopting the
That was seconded, right?
Barbie, I think, Ms. Ezell seconded.
Thank you, Barbie.
Okay, so all in favor of adopting these rules as presented?
Aye.
All right, any opposed? Okay, motion passes unanimously. Moving on to item 9B, which is proposed rules. I don't see anything. I just want to double check before passing on. There's nothing here right now. Okay.
There are no proposed rules.
Thank you. Okay, so now we're on to item 10. I want to just ask the board members, does anyone want to take a break, or do we want to keep moving? We've been at it a little over 2 hours now. All right, take it away, Dr. Merchant. Tell us about the supervisee survey results.
Okay, so I guess, how would y'all like for me to proceed? Do you want me to kind of give you a summary of the results, or do you just want to throw out questions you have?
Start us off with the summary, and then the questions will just flood forth.
Okay. So essentially, for the supervisee survey, kind of the history of it is that we had received reports of things like supervisee exploitation, or, reports of supervision cost, like being a barrier to licensure, things like that. At the national level, there's kind of been pushback about just the idea that supervision and like hours requirements are even like necessary, that maybe a master's degree should be enough for somebody to become fully licensed. And so we just had questions. And so we just kind of wanted to try to understand like kind of the rates of things like exploitive practices, especially around things like cost or like constellation of supervision. I'm trying to identify rates of what the literature calls insufficient or harmful supervision. Just trying to examine the preparedness for independent practice. Like, is supervision actually doing what we want it to? Like, is it actually preparing people for independent practice? Like, is it, covering all the things that it needs to cover? Is there value to it? Like, is there value to supervision? And then just trying to understand kind of supervisees' kind of overall general experience with supervision, and all of that to understand whether or not, like, are there things that we need to change about our rules in order to protect supervisees from exploitation, or from insufficient supervision or harmful supervision. And so we sent out a survey to licensees, and we altogether recruited 177 participants who had received licensure supervision in the last 5 years. We asked them a ton of questions. I think it was like 60 or 62 questions altogether. Most of them were like forced choice. So like selecting, it was an online student or I was a residential student. Several questions were Likert, and then we also had some open-ended questions just to try to like capture their experiences. And these questions were things about like their education and how prepared they were, and supervision costs, and the amenities that came with those costs, and constellations of supervision, and just kind of an overall sense of like how prepared supervision prepared them for independent practice. We used a measure of both insufficient and harmful supervision as well. We also had some questions about like if you've had to change supervisors, like what led you to make that change, and kind of what was their experience of having to change supervisors. And then just again, some kind of like overall experience and like rule recommendations. Despite being a really long survey, it said that the average time to complete the survey was only 20 minutes. So that's good, because I was a little bit worried about people getting exhausted while taking this thing, but they did good. So I am still in the process of processing the results. And so that is why you'll have kind of just the MS Word kind of summary. I guess maybe that's AI that did that. I'm not sure. But you have like the AI summary. And then you have like my additional analysis that I've tried to do with some comments and things in there. And like I said, I'm still processing, so it's not complete. But some of the results I found so far was that one, that master's education alone does not mostly or completely prepare associates for independent practice. And so the way we measured that is I went through the rules and we found 27 clinical and ethical tasks, and we just asked them, like, basically to rate how prepared they felt on those. And of the people kind of reflecting back, this is a like kind of a self-report, kind of looking back, retrospective study. So that doesn't, so that's an important limitation. But anyways, only like 1% of people said that their master's education completely or mostly prepared them on all 27 of those tasks. However, over the course of supervision, that rate rises to almost 50%. So by the time somebody has been in 2 years of supervision, about half said that they were completely or mostly prepared to complete all 27 of those tasks. So I do think that what we can draw from that is that master's education alone is not enough to prepare graduates for everything they're going to need to do as a marriage and family therapist, and that supervision definitely plays a role in preparing them for independent practice. We also asked about like supervision value. And so basically the kind of finding here is that while supervision is a financial burden, overall supervisees find the cost reasonable, and only a small proportion, I think it was like 10 or 11%, found supervision to be too costly compared to what they were getting. What was really interesting that even the participants paying the highest amounts, which we had two people paying 130 an hour and one person reported paying $150 an hour, that even those participants still found the value, like the cost was worth it. And so I thought that was kind of interesting. On average, participants were paying $50 an hour for supervision. Once somebody started paying $75 or $100 an hour for supervision, they started finding less value in it, and also were paying more, like the cost for supervision was more than they were getting paid an hour, if that makes sense. Um, I have not analyzed all the data related to insufficient and harmful supervision. But if you look at the charts on the like the MS word charts, it does seem that the rates of either insufficient supervision or harmful supervision are really low, which is quite a relief. So I was really happy to kind of see those preliminary results, and I look forward to kind of digging into that deeper. I do think the results also kind of affirmed some of the rule changes that we've had lately, and some historical rules that we've had. So, for example, limiting groups to six, that was actually the sweet spot of where everybody said that they thought that groups should be limited was around six. So I feel like that's just affirmation of that rule. The unlimited telephonic supervision, basically, people didn't really find a difference between telephone, Zoom, and in-person supervision. So I do think that it was probably okay for us to remove that limitation on telephonic supervision based on these results. In terms of rule recommendations, some of the things that people suggested were doable, but there were a lot of things that people suggested that are outside of our control. So things like advocating for associates to be on insurance panels, or a lot of people suggested putting a cap on what a supervisor can charge for supervision. And those are outside of the bounds of what we can do. But some ideas I think had promise. So things like putting guides or checklists, or like checklists of essential skills, or maybe doing some sort of feedback or audit process for both supervisors and supervisees, I think were some of the interesting ideas that were thrown out. We, as the committee, did not really have time to review all of the results to really make some good recommendations. And so, like I said, the next step is I need to continue processing the results, and then I would like to put together a supervisor survey. My goal would be to have the supervisor survey ready to go before TAMFT, so that way we can launch it either right like early April, so that I can recruit people to like fill it out at TAMFT. And then hopefully process the results over the summer, and then maybe in September be able to come to the board with maybe some recommendations based on the results of both the supervisor and supervisee surveys. So, what questions do y'all have, or what discussion do y'all want to have?
Is there a question about the time or the number of months that they should be supervised, like 12 months versus 24 months? I thought.
There was not a question about how long. The rule is 24 months. But in the comment, like the open comment section, a lot of people, like several, maybe like 5 to 10 people, commented that they thought that the supervision length should be lessened to like maybe a year. Or one person suggested like 1 year of supervision and then like 1 year of temporary license. The problem with that is that that is a statutory requirement. And so, like, we actually can't make that change unless, it requires legislative action to make that change. Any other questions or comments or recommendations or ideas?
I think you did a great job. I mean, it's amazing. I want to say I took the survey. And no, I didn't because it was for,
No.
yeah.
I was gonna say, if you did, you had to lie because I
I
don't think
know,
you
right?
did
No, it was the
supervision
other
for the
survey.
last
I'm getting them
4 years.
mixed up. It was the other
Yeah.
one. But I think how many people, and it doesn't matter what profession you're in, when you finish your degree, you're ready, you're an expert in that field. No, I don't think it's the case. So I really like the idea that we have this 2 years of supervision. If anything, I would ask, how do we continue to strengthen supervisors in what they do to make it more meaningful for the supervisee? And maybe this information that we got from here maybe can inform that process eventually going forward.
Right. There were a couple of people who, like, one person noted that she is now a supervisor, and she said that she was going to like steal the checklist, like the little 27 item thing, that she was going to start using that in her supervision, because that was helpful for her. Somebody else noted that taking the survey, an associate noted that taking the survey helped them realize that they weren't getting the supervision that they needed. And so I do think that it's good to have, I think if there's ways that we can kind of just more information, I think is helpful. So I think having some sort of checklist or something, I think would strengthen both supervisors to have a better idea of what they're doing or things they need to be doing, but also supervisees to realize when maybe they're not, supervision is insufficient. Okay.
Um, Dr. Merchant, thank you so much for your work on this. It was just invaluable information. Are you planning to publish in any way?
I mean, just on our website.
Oh, you could get an article out of this.
I'll think about it.
Yeah. Okay. Well, it's great information. Thank you for your hard work, and I look forward to seeing like how we use it moving forward to shape our rules and our processes. In the outreach
Sorry,
committee,
just one comment. I think from the professional point of view, right, or the public member point of view, how and where that relationship and how it's paid for is interesting. And so I'll be curious to understand what the supervisor says. And, because you come out of college and you're hoping to start making some money and get on with your career. And so it's a tough position that these people are in, that I understand it's probably been the norm for the industry, but how we can help be pragmatic in that is something that's on my mind, right? Because they're working for free to an extent. So
yeah, they're working. Oh, Rachel or Nicole, you're shaking your head.
They aren't working for free.
Oh, yeah.
They're not making as much as they will when they're fully licensed, but they are not working for free unless they're volunteering.
I'm sorry,
There
I
were
thought some people
Oh, go ahead, Will.
hourly charge that they were being charged by their supervisors more than the hourly rate that they're earning, though.
Yeah, so you might charge, for example, if I'm an LMFT associate, I may charge $30 a session, but I may be my supervisor who meets with me once a week might charge me 75 plus.
Okay, so there's an hours imbalance there.
Right.
That's helpful.
Now, when they're doing their internship, that could be free.
Yes.
Yeah.
That is supposed when they're students, they aren't supposed to get paid.
And there were a couple of comments on there that interns need to get paid, but I mean, interns are outside of our jurisdiction, period. And so that would also that's not something that we could fix either. That's out of our jurisdiction. Okay.
Just one last comment. Overall, I was pleased with the results. It seems like generally speaking, the supervisory um, time, this 24-month time, seems to be perceived as being very beneficial and positive for the associates that are going through that, generally speaking. And I was pleased to see that. There was one thing that was interesting on item question number 47 that says what factors influence your decision to change supervisors. If you cluster the last three or four together, conflict, insufficient supervision, harmful supervision, those total up, those cluster in a negative way to being 15 of that, which is something that would probably need to be looked at when we start talking to the supervisors by asking them, what are you doing? You know, how ethical are, not ethical, but how focused are you in covering aspects of appropriate onboarding into the field with these associates that you are? Because I've had some supervisees that have transferred to me that said they have gotten inadequate supervision and that they're not getting good feedback. They're not getting good mentoring. It's just like a show up and do a checklist thing. And that hurts because we're that's not our charter as supervisors. And that's one thing I'd like to get the supervisors together and say, okay, what do we do? And I know we can't impose things. So I mean, we can't put a cap on salary and payment. We can't do those things, but we can impress upon the supervisors the the functions of that role and what needs to happen with that.
Ms. Richardson?
I agree with Dr. Barty. I think we've all heard horror stories about supervisors, and my gut feeling is, as important as it is for us to do a survey of the supervisors as well, the supervisors that are being fled from will not be the supervisors that are going to be filling out our survey. So I don't think we're likely to get a lot of good data on the supervisors that you and I would find subpar. I think that's unlikely, but hopeful. That'd be great if they just came in and told on themselves.
And maybe since we do require supervisors to have certain, take the jurisprudence and have so many hours and stuff, that somewhere along the line, maybe there is a more intentionally, strategically focused training on here's kind of what is expected and how do you do, or something like that, as part of the CE requirements for that. Just spitballing that one. I don't know.
Well, the outreach committee has started to create we actually have created a supervision guidance document. And so again, I think we can, with these results, with the results hopefully from the supervisor survey, we can, I think, make that a more robust document, just to provide guidance and yeah. So
Well, one of the things I like is that document, the guidance document, initially started as let's create kind of guidelines for supervisors. But based on the feedback from this survey where the associates were going, I learned a lot about what I should be getting. That document, as far as guidelines, has kind of morphed into, okay, well, let's just make this audience both supervisors and supervisees so that then they're educated and aware of what they should be getting in supervision and what their options are if they're not, which I really appreciate the educational component of that.
any other discussion or ideas you have for the supervisor survey or just anything else y'all want to throw out there?
Well done. Well done. Valuable information. This is the type of thing I could see us doing, continually over a period of time to kind of do these types of feedbacks and assessments from our associates. Plus, it gives them a voice, and I really like that. So well done all the way across.
Yeah, there are some numbers on there that, I mean, they're fine. I can't think of an example right now. I'd have to go back and look at the data, but where it's like, 77% of associates were satisfied, but is that enough? Like, do we want a higher number? Like, do we want it to be 80% or 85%? And so I do think that if we were to do like a repeated if we were to do this, if we were to make some changes and do this again in 5 years, would we see maybe almost like doing some benchmarking where we can see if what we're doing is actually creating more satisfaction or reducing harmful supervision or, things like that. So, okay. Anyone else?
All right.
Okay, well then I think that concludes that item.
All right. Thank you, Dr. Merchant, for your work. All right. Item 11 on the agenda is recommendations for agenda items for the next meeting. I do know that our next full board meeting is May 29th, and then the one after that is July 17th. And then again on September 25th, and that carries us through the rest of 2026. Are there any specific items that we need to address on May 29th?
Did we move to 3 board meetings a year?
We did.
I'm sorry.
So then why do we have 4? Yeah, because we would have started in January, then we do May, July, September. Are one of those going away? That's a great question.
I'm sorry.
I
Is there 4 or is there 3?
I think there's only going to only be, I think we had talked about there only being 3, but yeah, I don't think the July one is in, I don't think the July one's happening.
Okay.
Yeah, I thought we had taken that one off.
After I opened my mouth, I was like, maybe I miscounted and she only said 3, but I thought she said 4. Okay.
Oh, you're right.
I think it was at our last meeting, I think, that we decided to move to 3. So this is relatively new. So.
Okay, so January, May 29th, and then again in September, and that'll be it for 2026. Thank you for that clarification, Mr. Price. Okay.
I'm just showing the upcoming meetings on the website.
Thank you. Thank you. Sorry for that mistake, everyone.
Not that I don't like you guys.
Yeah, I had it on my calendar for July too, so I'm glad we brought this up. Okay, great. Thank you for your hard work, everyone. I don't hear any other agenda items.
So then one, I think I flagged it, but an update on the CE broker, in May might be good.
Yes, absolutely. Update on CE broker. I think that for 2026, I would like to see that on every meeting agenda, just so we can track and see how the rollout is going. That's a good idea. Other ideas about agenda items?
Well, if Dr. Merchant is going to get this supervisor survey before the April TAMFT meeting, could we expect preliminary results by the May meeting, or would that be ambitious?
Probably not. I mean, I hope to get it out early. Like, even if I were to do it in April, I'd probably leave it open for all of April. And then my May is incredibly busy. So I probably won't be able to do it. I won't be able to analyze results probably until over the summer.
Okay.
So.
Okay. Hearing no other agenda items, then I would look at item 12, which is a motion for adjournment.
I will make a motion. This is Dr. Merchant.
Is there a second?
Richardson will second.
Any discussion? All in favor?
Aye.
Aye.
All opposed? Stay safe and warm, everyone. The motion passes. Thank you very much. Have a wonderful weekend, everyone.
And Dr. Elder, thank you again for SMU's gracious invitation. Let's try to make this happen again.
Yes.
Dr. Hampton and I loved the SMU environment.
It looks cozy. So yes.
It looks great. Maybe next time we do it in a time of year that we don't typically have storms.
Good call. Good call.
Like May, not September. That's hurricane season. So
Take care, everybody.